Okay, welcome. Good afternoon, everyone. Thank you, everyone for joining us here today for a discussion of important issues with Attorney General Skrmetti. I'm Mike Polson. I'm a member of the Governmental Affairs Committee, TVPOA, Government Affairs Committee. Brief history on General Skrmetti. He was sworn into an 8-year term as Tennessee's Attorney General and reporter on September 1st of 2022. Prior to his current role, General Skrmetti served as Chief Counsel to Governor Bill Lee and as Chief Deputy Attorney General to his predecessor, Tennessee Attorney General Slattery. Excuse me, Slattery? Did I get that? Slatery, okay. Before working for the state of Tennessee, General Skrmetti was a partner at Butler Snow LLP in Memphis. His legal career began with nearly a decade as a federal prosecutor. He worked at the Civil Rights Division at Maine Justice and then at the Memphis U.S. Attorney's Office. In addition, General Skrmetti taught cyber law as an adjunct professor at the University of Memphis. General Skrmetti earned honors degrees from George Washington University, the University of Oxford, and Harvard Law School, where he was editor-in-chief of the Harvard Journal of Law and Public Policy. Following law school, General Skrmetti clerked for Judge Stephen Colleton on the U.S. Court of Appeals for the 8th Circuit. He lives in Franklin, Tennessee with his wife and 4 children. Welcome, General Skrmetti. One quick thing. He's obviously anxious to address you all. A couple of things, administrative housekeeping things. First of all, also would like to acknowledge that we have Lowell Russell, our state representative, with us. Thank you, Lowell. We also have Henry Cullen with us, our county commissioner. And a POA board member, John Argalas, and our CEO, Mr. Chet Pillsbury. Okay. I'd like for everybody to stand and pledge allegiance to the flag, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Have a seat. One more housekeeping note. Government Affairs Committee is a committee whose primary goal is to act as a liaison and advocate for the village and an educator of elected officials and commissions as well as villagers. Part of our mission is to be a leader in community activism and get out the vote efforts. We serve as liaisons to organizations engaging with government and quasi-government officials, bringing Tellico Village issues to them for consideration. This goal is why we offer this forum today. This forum will be recorded for posting later on the Tellico Village Network. And as far as questions, Mr. Skrmetti will obviously talk and have a very informative talk with us. And after that, if there's time left, which we hope there is, we will have questions from the audience. After anyone can come up, ask a question, please state your name. We have a light system on the podium. You will have 1 minute to ask your question. Please be succinct and to the point. If you have multiple questions, ask only one question at a time. If there is no one behind you, you may ask another question. We look forward to a civil debate, discourse, information obviously that we all need to hear. So please keep in mind that Mr. Skrmetti is our invited guest and is fully deserving of everyone's respect and courtesy. Rude behavior or other outbursts from the audience will not be tolerated. The last 10 minutes, after 2 hours, if there are no further questions, I'll ask Mr. Skrmetti to come and give some wrap-up comments for us. The floor is yours, sir.
Thank you. Thank you so much for having me. I was a little excited to get up here. Forgive that. But The first thing I want to say is, last time I was here, you gifted me with this tie with the Constitution on it, and I really appreciated that. And I was elected the chair of the policy group for the Republican Attorney General Association a little while back, and I wore this tie there specifically so that when I came back to talk to you, I could tell you that I wore the tie when I was elected the chair of the policy group. Thank you, because, and I got some questions from Steve Marshall, the Alabama AG, and Chris Kobach, the Kansas AG, who really liked the tie. And I told them, well, there's this group that had me come talk. They gave it to me to make sure I kept in mind what I was supposed to be thinking of as the Attorney General. And that's really what it's all about. Everything we do, everything the state government does, everything the federal government does, only happens because the people ratified the state constitution, the federal constitution. And if we lose track of that foundational belief for our existing governmental structures, we're going to stray really far. And I think it's pretty clear that we've strayed really far, that we've forgotten a lot about why we have government and what authorizes the government that we have, why people are entitled to do some things and which things they're not allowed to do no matter what position they hold. So I just wanted to thank you again and let you know that I have not forgotten. I was warned not to get gravy on it. I did not get gravy on it. So I'm really grateful for the tie. The second thing I want to say is just how great it is that you are here to ask questions, to listen, to understand what's going on. Because we live in a governmental system where the people rule, and the people need to be informed to make good decisions. Journalism is not what it once was. There's some reasons for that I'm going to talk about a little bit. Not necessarily excuses, but there are some reasons why it's not what it used to be. And that means people have to work harder to get informed sometimes. And so the fact that you're here participating and paying attention is commendable, and it deserves to be recognized every time it happens. Because if the people aren't informed, if they don't know what's going on, if they don't understand why the things that bother them are happening or why the things they like are happening, they're not going to be in a position to keep getting the kind of government that they want. It's hard to be a self-governing people. It takes work, it takes effort. It takes effort not just to have self-government at one time, but to perpetuate that for the generations to come. And so the fact that you're here means a lot, and I appreciate that. Both as somebody with kids who wants them to grow up benefiting from all the blessings that this country gives, and also as a public official who knows how important it is to have an informed electorate. So with those preliminary intro pieces, I'm going to talk a little bit about what my office does. I think many of you were here last time I spoke, so I'm going to compress a little bit of the overview. But I want to put out just some of the high-level stuff just to make sure everybody knows. The Attorney General in Tennessee is the state's attorney. My office represents the state in every matter in a court except criminal prosecution. For criminal prosecution, it's the district attorneys general that do it. And I don't have any significant ability to do that. There's a couple very, very narrow statutes that give me some authority in environmental matters and in certain public corruption cases, but it's really limited and it almost never happens. But with that caveat, every other piece of litigation that affects the state of Tennessee, whether the state's being sued, whether the state's suing someone, whether a state official's being sued in their official capacity, the Attorney General's office represents the state and its officials. We have well over 10,000 cases going on right now. At any given time, it could be as high as 16,000. We're trying to be a little more efficient and bring the floating number down some, but there's a lot. There are a lot of cases out there, and some of them are little cases. Some of them are things like if someone busts an axle on a state-maintained road, then they go to the Claims Commission seeking reimbursement, and we have lawyers that represent the state in those proceedings. And, those are relatively light lifts. There's not a lot going on. And then we have cases like the litigation over school funding, where there was billions of dollars at issue, and multiple law firms representing multiple counties and teachers groups, and the big constitutional cases. So one example from that is the SB1, HB1 litigation. SB1 and HB1 was a law passed not that long ago. Representative Russell probably remembers it very well, where our General Assembly, a bipartisan coalition of our General Assembly, passed a law saying that doctors could not provide surgery or hormone treatments or puberty blockers for gender transition purposes to kids. So if you're under 18, they can't give you those services. That was attacked as blatantly unconstitutional by a bunch of people. There were editorials, there were people, lawyers coming out saying, oh, how dare Tennessee do this? There's no way they can do this. Every federal court that had looked at it up to that point had said it was unconstitutional. We had the ACLU, we had Lambda Legal, we had a big New York law firm, and we had the U.S. Department of Justice jump into that case. There were about 30 lawyers on the other side. We did not staff it with 30 lawyers. I think we had 6 or 7 on that one. But what I'm trying to say is some of the cases are very complicated and involve a lot of work. By the way, we won that case. We were the first state to win. Thank you. We lost in the district court. We filed an emergency petition to the Sixth Circuit. Sixth Circuit enjoined the law. Then the Sixth Circuit said the injunction was permanent. Now the U.S. Supreme Court is going to look at the case, so we'll be up there in a few months. My Solicitor General is going to argue it. It's the first constitutional case to look at gender identity issues. They've looked at it in a statutory context, but never in a constitutional context. So it could be a very significant case. So next time I come, I'll update you on that, hopefully with good news. But we are in the middle of the fight on that issue in a number of ways. One of the things that's been really important to me personally is the regulatory litigation we've been engaged in against the federal government. It's not everything the office does. It's one of the parts that gets the most attention, and it is important. We do a lot of other stuff, but I've always cared a lot about administrative law. I'm one of the 12 people in America that feels that way. And when the General Assembly very generously authorized the creation of the Strategic Litigation Unit to sue the federal government and protect Tennessee's interests, we got a great team together, just a phenomenal group of attorneys, and we've been very, very busy in that unit suing the federal government. And the goal is not just to mess with the federal government, the goal is to reassert the constitutional order. So in our system, we have separation of powers. So in the federal Constitution, there's the executive, the legislative, the judicial branches. They're all supposed to push against each other to hold each other in check for the purpose of avoiding a concentration of too much power. And then the federal government has an enumerated list of powers. There are certain things it can affect. Everything else is left up to the states or the people. So we have state governments that in theory should be pushing back against the federal government to stop overreach. And over the last probably century, but in particular over the last 30 or 40 years, we've seen an increasing concentration of power in the agencies in the federal executive branch. So these are the bureaucrats. Typically, you don't know their names. They don't know who you are. They don't necessarily care who you are. They're making the rules that are going to govern the country. Well, that's not how the Constitution works. When you're making big rules that affect a lot of people, the people's elected representatives are the ones who are supposed to be making those decisions. It's a democratic process. We live in a constitutional republic, and it is not up to faceless bureaucrats to tell us what the law is. I've no doubt that most of those people are well-intentioned and think they're doing the right thing, but they're not. The Constitution says the people's elected representatives should make the decision. And it's important because you have the ability to talk to your representatives. You know who they are. You can vote them in. If you don't like what they're doing, you can vote against them. You can go out and campaign for other people. You can try to persuade other voters to vote for people who agree with you. It's an open and transparent process. And even if you lose sometimes, at least you know the rules. You know, I need to go out and convince more people. I need to work harder. We need to recruit better candidates. Whatever, there's a way for you to change what the law is. When it happens in the agencies, it's an opaque process. You don't necessarily know what's going on. The input that they're largely getting comes from a very narrow group of people who have very narrow interests. So if you care about one particular issue that's affected a lot by a rule, and the agency doesn't really care about that issue, then your voice is effectively silenced. And these agencies are building off of statutes that Congress has passed that give them some authority, right? I mean, there is a role for the federal executive branch. There are things that they should be doing. There are agencies that should be there. We can argue about whether all of them should be there. I think there are good arguments that there are some that aren't necessarily a net positive, and we'll leave it at that. But, you know, there's law that authorizes them to exist. There are statutes that lay out what their authority is. And they've taken those statutes and run wild with them. And I'm going to give you one example. There are a lot recently. We're litigating a bunch of them right now, some dealing with ESG and environmental issues, some dealing with, well, the appliance stuff is ESG related. You know, they don't want you to have a functional washing machine and clothes dryer. So we're, as an occasional user of such devices, I want them to work better. But, you know, one area where it's just absolutely clear that the federal government is overreaching on the regulatory scheme is with the gender identity issues. Day one, President Biden came in and said, I want every single federal agency to reinterpret the sex discrimination provisions in whatever the operative statute is to say that it applies not just to sex discrimination, but to gender identity and sexual orientation. And so you've got all these regulations that were built originally around these anti-discrimination provisions. Probably the biggest and most important of those is Title IX, which is the education anti-discrimination provision. 52 years ago, Congress passed a law saying you can't discriminate against women in education. It applies to lower education, so elementary, middle, high school. It applies to higher education. You cannot discriminate against women. It's been a good law. It's done a lot of good things. It's created a lot of opportunity for a lot of people. Until the late Obama administration, there was never any question that what the law that said you can't discriminate based on sex meant was that you can't discriminate based on sex. Nobody thought it meant anything other than that. There was some argument over the scope of, you know, what constitutes sexual harassment, but everybody understood it meant you can't treat women differently than you treat men. But in the late Obama administration, they floated this trial balloon of a rule saying, well, it also incorporates this other stuff. And then the Trump administration came in, immediately repudiated that. But then the Biden administration came in and day one said, nope, all of these rules need to be reinterpreted to cover sexual orientation. So we finally, after several years of them writing it, finally got the Title IX rule that they proposed. And the rule was radical. Under the Title IX rule, and this is based on admissions by the DOJ's own attorneys in our litigation against them up in Kentucky, it would require schools to police pronoun usage. So even if a teacher or a student or an administrator or somebody visiting the school did not believe that gender identity should determine someone's pronouns, if they wanted to call someone he because they were biological male or she because they were biological female, the school would have to make sure that they didn't do that. They had to either kick them off the premises or otherwise make them use the preferred pronouns. It would have allowed any boy, not just a boy who identifies as a girl, but any boy to stroll into the locker room and the showers. And this is explicitly admitted to by the DOJ lawyer. So because you can't question somebody's gender identity, because that would be discriminatory under their rule, if someone looks like a boy, you're not allowed to say, do you identify as a girl? You just have to let them do as they will. And because you have to allow people to use facilities based on their gender identity, it means that there is essentially no sex segregation of anything. If a boy wants to wander into the girl showers, there's nothing to stop him. And if you try to stop him, you're in violation of federal civil rights law, according to this rule. You know, and it's unclear the extent to which the rule would have applied to sports. According to the Department of Education, they have another rule coming that covers sports. But if you just read the language of the rule, private litigants could come in and use that language to sue, saying there should be no sex discrimination on sports teams, that anybody should be able to play on the team that they want to play on based on their gender identity. So these are radical changes that matter a lot to a lot of people. There are people on both sides. There's a big argument here. I mean, I think everybody is aware there are folks on the other side of the issue who vehemently believe that gender identity should be the determining factor, and that discriminating on that segregating on the basis of sex is discriminatory, but that's not what the law says. And we have a system to allow for that debate to happen. We're allowed to disagree with each other. People are allowed to be wrong. We're allowed to come together and fight about what the law should be, but we got a process for that, and that's a political process that happens in the legislative branch. So the fact that the executive branch is taking this huge, profoundly important social question and letting faceless, and again, I don't doubt that their intentions are good. These are people who are trying to serve the country. I don't want to personally attack the faceless bureaucrats, but they are faceless bureaucrats. And they're making these huge decisions about what the law should be. I don't know what's beeping up here. I'm a little concerned. I'm not getting tackled by any security folks, so I'm probably okay. But okay. Excuse me. But the bureaucrats should not be making the law, and the president cannot decide that he wants what Congress has written to mean something different than what it actually means. The words matter. The words are the law, right? You can't read anybody's mind. You can't go back and piece together what they meant. What you have are the words on the paper that got voted on by Congress, that got signed by the president. That's what the law is. The law doesn't, we can have a discussion about natural rights, natural law, all that, but in the American constitutional system, for the courts to look at what the law is, all they can do is read the words on the page in the context of, an understanding of what those words mean based on the time of their passage. So you can't read these statutes and realistically think that they mean these expansive gender identity-oriented things. Even if you're somebody who thinks that the gender identity issues should be covered by the law, they're not covered by the existing law. It's such a stretch. And when the executive branch does this, when they take the law and rewrite it in an opaque process where people feel like they're powerless, where people feel like they're helpless, it undermines the legitimacy of our entire constitutional system. People feel disconnected from the law, they feel alienated from it, and eventually they feel a whole lot less obligated to respect it. And we've got a really good system. I know there's lots of faults, there are lots of things we can complain about with respect to how government works, with respect to people who get elected, all these things, but look at the rest of the world. We have it better than them. We are so blessed to be Americans, and if we start messing around and undermining the foundations of our Constitution, that's gonna stop. And we're coasting on inertia right now. A lot of the energy that motivated America's greatness has expired. And there's still a lot of great stuff happening in this country, but you're also seeing places where things are falling apart. And one of those areas is the rule of law, and we gotta stop that. We gotta stop that. It shouldn't matter which side of the politics you're on. There are so many different things that we can disagree about in terms of what the policy should be, in terms of, what the federal government should be doing. There are limits on what the federal government should be doing that are just carved into the Constitution, but within the scope of what's allowed, there's a lot we can disagree about. There are issues that the federal government could take up or could leave to the states. There are things that the states can address very differently or not address at all. We can argue about all that, but we shouldn't be arguing over the fact that we have legislatures that are making those decisions, and that the executive branch's role is limited to executing the law and not making the law, and that the courts are bound by the words of the law and can't just come in and decide they know better than everybody else what the law should be and rewrite it themselves. So, again, we do a lot of things other than that, but just, from the perspective of somebody who wants his kids and their kids and their kids and their kids and their kids to enjoy the blessings of liberty, I care a lot about the constitutional structural issues, and we've been fighting really hard on that. So with Title IX, we got an injunction saying that the law's not going to go into effect while the litigation's pending. So that was the first step. Part of getting that is showing to the court a likelihood that we're going to succeed. So we take it as pretty likely that we're going to win the case overall because the court had to find that we probably would to give us the injunction. And if you read the opinion, it's a very strong opinion saying we're probably going to win. The Court of Appeals looked at it. They agreed with the district court, so we won there. The DOJ, in the most complicated thing I think we've dealt with from them, asked the U.S. Supreme Court to issue a partial stay of the injunction. So the court enjoined the whole new Title IX rule. The DOJ is asking them to unenjoin pieces of it. It's very confusing. The Supreme Court should be ruling shortly on that. Our briefing was very persuasive, but of course you never know what's going to happen. So that's where that stands. And then but it's so many other rules. Title VII, the employment law, there are EEOC guidelines that say, among other things, that if you're an employer, if you own a business, and somebody comes in and misgenders an employee, that you essentially have to correct them, and if they're not going to change their mind, kick them out of the business, which is imposing a huge burden on business owners. I mean, they don't want to be the culture war police. They want to get customers in, keep them happy, make money, and enjoy good word of mouth and keep running their business. I think part of the problem here is the people who are writing these regulations, who are so insulated from everybody else, don't appreciate the on-the-ground impact this sort of thing has. If you're a business owner, again, whether you agree with the policy or not, you're going to recognize that is a heavy, heavy burden to bear. And if a business owner wants to choose to do that, this is America, it's a free country, it's their business, they can choose to do that. But for the government to come in and make them do that is overstepping what the statute allows, and it's got such a heavy burden on their ability to do business the way they want to. Similarly, we've seen this effort, it's called the whole of government approach. And you see it with the gender identity issues, but you see it with environmental issues too, where the idea is every part of the government is going to be working to further a particular policy. So with the environmental and social and governance stuff, you're seeing executive orders telling everybody, or maybe not even formal executive orders, but policies from the top down telling everybody you need to be more environmentally conscious, we need to fight climate change. And what that does is convert agencies that have expertise in certain areas into general environmental agencies. So they had the Federal Trade Commission looking at what counts as recycling for people who say they're using recycled materials. And they had this super complicated scheme that would have made like 90% of recycled stuff not count as recycled. Well, that's an environmental regulation. That's not a consumer protection regulation right there. It's not an unfair trade practice to say that this type of recycling is recycling. If they want to regulate it as an environmental matter and there's a statutory authority, we have an environmental protection agency. But this is using consumer law to try to further a policy that has nothing to do with consumer law. Same with the Securities and Exchange Commission. There's this climate disclosure rule that would be incredibly onerous on small businesses, on farmers, where they're required to assess the environmental impact of what they do, report it. The net effect would be to wipe out small businesses across the country. But that's in furtherance of a policy that the executive branch thinks is very, very important. And because it's done through this opaque process where people don't get a chance to weigh in, it doesn't really account for the absolutely outsized burden it's going to have on people. I want to talk a little bit about some of the non-constitutional, non-federal stuff that we're working on too, because some of it is motivated by the same principle. The whole point of our government is to avoid the concentration of power. Because if you concentrate too much power in too few hands, no matter how good your intentions, no matter how good the intentions of the people who get the power, they are liable to abuse it. And if they don't do it at first, they're going to do it eventually. And so you need people to check each other. You need to make sure that nobody has the ability to control things to the extent that there's not a remedy out there. So that applies to the government, but it also applies to business. And I want to be very careful with this because Tennessee is a pro-business state. We're one of the most business-friendly states in the country. We're going to stay that way. It is very important to the overall values of the state that we be a place that people can come and be free to do their business. But we still have antitrust laws, and there are federal antitrust laws, and business works because there's competition, because business people are motivated to provide a better product or a better service at a better price, and consumers benefit. But when the market breaks down, when there's too much consolidation of power, then consumers don't benefit anymore. At that point, the monopolists are able to set whatever price they want, and there's no countervailing force to drive those prices down, to give people more choices, to give people better quality product, and that is a big problem. So for a long, long time, there wasn't a whole lot of antitrust work. And this part's not going to take too long. I know everybody gets bored about antitrust, but it's important, and my office is doing some really neat work on this that I want to brag about because my team is just, they're doing great. For a long time, there wasn't a lot of antitrust enforcement. There was the Microsoft case, which is a big one about 25 years ago, and that was sort of the biggest blip, and it's been relatively quiet, and now it's really ramping up. And the neat thing about it is it's bipartisan. For all the disagreement we have, for the fact that DOJ is suing me personally by name in other big cases, we get along great with the antitrust division. We work with some of the Democratic states on these issues. And as an American, it's nice to know that, we can still all get together and work on things together sometimes, because I worry occasionally that we're losing the ability to do that. So these are bipartisan efforts, and we're looking at a lot of tech companies because there's been incredible consolidation there. So I want to brag about a recent victory because I had 2 lawyers up on the trial team in this case, and it's a big one, and that's Google, where we just got an order from a federal court confirming that Google is in fact violating federal antitrust law and does have an illegal monopoly. So thank you. I'm so proud of my team. I wish you could have seen how hard they worked because you would know like your tax dollars are being very well spent. They were unbelievably diligent about this. We had 2 guys basically move up to Washington for 2 months to do the trial, and they did a phenomenal job. And they were paired up with some really great people. They all worked together super well. But that's a big one. Google controls the flow of information. There are other avenues for information to get out, but so much runs through Google, and there aren't choices out there. They've effectively crushed competition for internet search. There are some competitors, but they are tiny, tiny competitors. And I don't want to get into the details, in part because I'm sure I'd mangle them in recounting it. But they've taken many sophisticated steps to ensure that there's no viable way forward for anybody to compete with them. And as a result, when they start dropping search results for certain topics, nobody can do anything about it except complain. There's not really an alternative. I mean, I use DuckDuckGo sometimes too because it's an alternative, but even the DuckDuckGo people would tell you we can't provide a lot of what Google does. I mean, it's a much, much, much bigger company with vastly more resources, and they've made sure that nobody else can scale up to compete, and nobody really wants to scale up to compete because it costs tens of billions of dollars at this point. So the Google case is a big one. We have, this one is not the case of the century, and there's a wide spectrum of things that we look at, but Ticketmaster and Live Nation, the ticketing company, has had market problems for decades. And, I think the thing that stands out most to me is when someone did an analysis and said, it is cheaper to fly to Europe to see Taylor Swift or Beyonce perform than it is to go to a show here. That's an indication that the market might be pretty broken. And again, without going too far into the details, there's some pretty sophisticated interlocking operations going on that make it really hard for someone to compete without, at the very least, cutting in the monopolist for a big piece of the action. And that hurts people. I mean, that's money that's getting taken from consumers that in a more competitive environment wouldn't be, but it also hurts the people who are producing that stuff. Not just the artists, but everybody involved in the live music and performance industry, many of whom live in Tennessee. So I'm really excited about that case. Again, we're teaming up with other states. We're teaming up with the Department of Justice on that. We've been pretty outspoken about this issue here in Tennessee for a while, and we're a ways off from trial, but at the very least, we have a good case to bring there. And you got to push back. I mean, when you get a situation where nobody can compete, it just metastasizes and it gets worse and worse. And even if it's an industry that's not the be-all, end-all of democracy, information flow is obviously incredibly important. And if there's a problem there, we have to address it immediately. But even in industries that are just, entertainment, we need entertainment, we like entertainment, and it's not right that our entertainment options are being constrained and the people who put that stuff together are being hurt because the market stopped working. We need functional markets. So the antitrust enforcement has to be undertaken very carefully, because you don't want to just beat up on businesses that are successful. You don't want to just beat up on businesses that get big. But where the markets stop working, where you have evidence of anti-competitive activity at a big scale, I think it's right that we step in, and I'm proud. Our folks are doing a good job in that. Another consumer-related matter I want to talk about is the mental impact of social media on kids. And this is an area where there's a lot of evidence. Every month or two, there's more evidence coming out showing that there is a big effect. We've got a bunch of experts lined up to talk about that. There's a book that came out recently by Jonathan Haidt that talks about it in detail. But there's also a lot of internal documentation from the tech companies saying they knew it. They were aware, they had people inside. This whole case started when whistleblowers came out and said, this stuff is hurting kids. We said to all the people we work for, this stuff is hurting kids, and they didn't make any changes. So if you look at the evidence of anxiety, depression, suicidality, sleep deprivation, all these metrics for mental health, teenagers are just falling off a cliff over the last 10 to 15 years. And you can tie it directly to the broad adoption of social media and to the increasing sophistication of these social media platforms. Because I don't know if you remember, like 20 years ago, Facebook was pretty rudimentary. It was fun, but you would get on there, you would write something on somebody else's wall, they'd write something on your wall, eventually you could put pictures up, but it was a fairly light touch. Every year since then, it's gotten more and more and more sophisticated. They brought in people who design casinos to look at what it takes to keep people engaged in something longer. They've brought in neuroscientists to look at the brain chemistry that motivates people to continue to engage with something. Because their user base for these social media platforms is billions of people, they were able to run tests with hundreds of millions of participants saying, I wonder if we had a different sound for an alert, which would get more people to use the platform for longer, or what shade of blue should we use here? Which one's going to drive engagement further? So every single piece of these platforms is incredibly refined and designed to keep people engaged. And the alerts that pop up, so if you haven't been on for a while, you get a reminder saying, hey, it's been a while, maybe you should log in. The algorithm's so sophisticated that people who have looked at it said, if you're a kid, it will find somebody that you were either in a relationship with and stop being in a relationship with, or there's indications that you had a crush on, and start throwing you information about what they're up to try to drag you back in to log into the platform. So it is designed to be addictive. It's designed to be hard to stop using it, and it's designed to make you want to use it all the time. And it's not addictive in the same way that, say, crack is addictive, but it's very deliberately designed to be hard to stop using. Now, they're allowed to design their product however they want, but particularly where kids are concerned, if they're causing harm, they need to address that. They need to very clearly warn, and because they've taken so much care in designing the product, and because they have so much data about users, they can identify who the young users are, and they can dial back some of the addictive stuff. They can make it harder for them to use it at night. They cannot send them reminders at night. They cannot send message updates at night. In theory, they could not do things during school hours. They could make it harder for the kids to use it then. I do not run a social media company. If I did, I would have arrived in a much nicer car. So it's not my place to micromanage exactly what they do, but I can say the law says you can't put out an unsafe product without warning to kids. I can say you got to do something different, and the courts can tell them they have to do something different too. So ideally, they would say, we as good citizens and good parents recognize the harm that this is causing and want to cooperate and figure out how to solve it. I don't know that they're going to do that. We've got a killer litigation team ready for the first case, so if they don't do that, we're going to be just fine. But one way or another, we got to fix it. And that I think is most of the really big stuff that we have going on, but there are so many cases that you never hear about unless they go awry. And so many people working hard just to keep the wheels turning. They're not looking to light the world on fire. They want to be competent attorneys doing good for the state because they know the state does good for a lot of people. So things like state contracts, things like taxes, where we want to make sure that we're following the law, but we want to make sure everybody else is following the law too. Bankruptcy proceedings. So if somebody owes the state money and declares bankruptcy, we have lawyers who will go out and work to make sure that we get our fair share of that. And that's everything from the Purdue Pharma bankruptcy, which is one of the biggest in history, to individuals with very small estates who nevertheless have some stake for the state in there. Public records requests. We have 17 litigating divisions. We have about 200 attorneys. Most of them are in Nashville. The large majority are in Nashville. We have very small offices that only do eminent domain work in Knoxville, Chattanooga, and Jackson. We have a little bit of a bigger office in Memphis. I really want, if I accomplish nothing else, I really want to build up our offices outside of Nashville. I think there are good attorneys that we can hire. Yeah, please clap for that. I think Representative Russell left, but if you don't mind, relay this message to him. No, I think it's really important. There are good lawyers across the state. Nashville is so expensive that it's pretty hard for us to keep people. You get a good attorney, you give them some experience, all of a sudden they can make 4 or 5 times as much money somewhere else, particularly in Nashville. But it's also a perspective issue. There is a little bit of a bubble in the middle of the state. Spent a lot of time in Memphis, and I appreciate that the further you get from Nashville, the more often you occasionally feel forgotten. And I don't think anybody in Nashville is doing that on purpose, but it's such a big, dynamic city. There's so much going on there. All the government agencies have most of their people there, and it's easy to get myopic. So I think it's really important to make sure that we've got people coming in from across the state. And even if it's just a matter of running into them when we have it used to be twice a year, now it's once a year, we get our whole office together, or just going by to check in on the office, somebody who's local, who understands what the significant issues are in a way that we can try to be responsive. Because I don't want to be up in an ivory tower. I think it's important that we get out there, because even though I'm not elected and I'm not running for anything, I think it's really important, given the scope of work that we do and the importance of a lot of that work to everybody, that we listen, that we let people know what's going on. You care. People care about this stuff. And I don't want people to feel like the AG's office is just arbitrarily making big decisions that affect them. I want them to understand there are reasons for it, that we don't make the policy, but we're going to do everything we can to make sure that the state's policies are allowed to go into effect. I'm not there to say what the law should be. We have a governor and a legislature whose job is to run the state, to make the big policy decisions. But I'll operationalize that. The job of attorney generally is a service position. And I've got clients and I'm going to do right by them. So I appreciate the chance to come talk to you about this stuff. I could go on about some of the other things we're doing, but I think I've hit a lot of highlights here. Oh, one other one before I open it up to questions. This is my favorite case that I'll probably ever get to work on in my career, and that's the NCAA case. I have had big concerns about the NCAA for a long time. they say they're just a membership organization and they're nothing but the schools, but every school is terrified of them. And the enforcement people from the NCAA have behaved really poorly, very arbitrarily, very unkind. In the past, they've dealt with some other schools in Tennessee. And so when the University of Tennessee was facing significant challenges, we took a look at the NIL law, and lo and behold, it was the NIL rules from the NCAA, compared them with the NIL law that our General Assembly passed, which recognizes what the U.S. Supreme Court recognized, which is that players have an intellectual property right to their name, image, and likeness, and student athletes don't surrender that right just because they go to college. We saw that the NCAA's rules on this were fundamentally anti-competitive. They didn't let players properly determine the value of their NIL rights on the market. They said the players couldn't negotiate until they committed to a school, and when you've already committed, there's not, I'm not the most sophisticated businessman, but once you've said, I'm going to your school, there's only so much room there to say, now how much are you gonna give me? And obviously they're not negotiating with the schools, but they're negotiating with the collectives that are generally geographically based and aligned with the schools. So Judge Corker up in Greenville took a look at this and said we were likely to prevail, that this sure looked like a Sherman Act violation. So when the NCAA was investigating, they were suddenly stopped because they're not allowed to enforce their NIL rules in Tennessee for the time being. So I was very happy about that. I don't want to speculate too much, but I think it would have been extremely, extremely bad for the athletic program. And the basis for the investigation was just absurd. It's, one of the problems with the NCAA is they can ignore massive problems if they want to ignore them, and they can escalate the tiniest ticky-tack violation into something devastating if they want to. And knowing the hundreds of millions of dollars that UT Athletics brings into the East Tennessee economy, what might not have mattered that much to the NCAA matters an awful lot to Tennessee, and especially to the student athletes you can't have college sports without the kids. And if everybody else is getting rich and the kids aren't, that's just not right. So anyway, I did want to flag that. When we went to court to argue the injunction, there was a giant Power T banner hanging on a crane across from the courthouse. And it was the most dramatic entrance I've ever had litigating anything. So I always appreciate a chance to tell that story. But I'm happy to take your questions. There are things that I sometimes can't answer because of attorney-client privilege or because of ongoing litigation, but I will do my very best to answer what you got.
Anybody like to come up and ask a question? The podium is open.
Good afternoon, sir. First, I'd like to thank you for your service. Thank you for your service to the state of Tennessee. As a retired federal law enforcement officer, I have a great interest in border issues and immigration issues. That was my career. And I'd like to ask you if you think that the birthright citizenship clause of the 14th Amendment will ever be formally adjudicated by the Supreme Court.
I don't know whether they'll take that case or not. You would think, given how important it is, it'll probably make it there eventually. But the Supreme Court doesn't take that many cases these days, so it's really hard to say. If I can answer some adjacent issues, though, because this has been one of the big sources of frustration for me. We have immigration laws. The federal government's not enforcing them. The states have tried really hard to do everything we can, and we constantly hit walls in the courts who say over and over, you can't make the federal government enforce the law. That's a discretionary decision by the executive branch. We can't legislate because we're preempted by a lot of the federal immigration laws. Now, there's some ancient precedent from the 1830s that may help us, but we got to work through that. And right now, the big litigation in Texas is, do the states have an independent authority to protect their borders? And we're fighting on that front. We'll see where it goes. So immigration matters a lot. Obviously, birthright citizenship differentiates us from a lot of places and creates an incentive for illegal immigration that other places don't have. Judge Ho in the Fifth Circuit has written about how he thinks it's been perhaps interpreted wrong. There's a lot of scholarship on that issue, but who knows if the court's ever going to take it up.
Do you think the state of Tennessee may ever initiate that case in federal court?
Possibly. I mean, it depends on how it comes up. It depends on what happens. The determination about citizenship is a federal function, so we may not get very far if we take a shot at that. But I've got people who have been consistently looking at immigration issues since I started, just trying to come up with something. All the Republican AGs get together regularly, and that and the administrative state are probably the two things we talk about the most. And I've sued Homeland Security just trying to get more information about what's happening in terms of people being brought into Tennessee. They're being very opaque about that. But the ability of the lawyers to fix this is extremely limited. Ultimately, it comes down to elections.
Thank you.
Thank you.
Good evening, Gary Bush.
Hi.
Nice to see you again, and a pleasure that you're here. I've got a little different question. It ties into monetary funds coming down from the federal government that are tied to programs. One of the things the governor's approved in his budget is clear language to authorize funding of the Tennessee Volunteer Emissions Strategy, which is Tennessee's arm of the Climate Action Plan, which is funded through the EPA. Climate Pollution Reduction Grant Program, basically, which is established in the Inflation Reduction Act of 2022. Our state plan mimics currently on books the unlawful federal mandated Green New Deal plan that was based on the United Nations Agenda 21 adopted in 1992, which is clearly in violation of the Public Chapter number 479 and Senate Bill number 1147, effective on 5/17/23. And per UN documents, basically they've stated the rigidity of our Constitution is a hindrance to their ability to accomplish mandates and wield authority to accomplish their goals. Not only are they structured that way, the WHO is structured that way, and we have administration. So how do we as people work with the Attorney General's office to stop when those mandates come down from outside the U.S. country, and they're mandating? We get an administration that goes rogue and says, well, we're going to force this down on the states.
So, and we've seen this in different contexts where there are international bodies that are trying to push out something that they want to be law. And there are some ways that they do it that are more subtle than others sometimes. The issue with the spending clause authority, and this is we're litigating this in some other contexts, is if the federal government clearly states what the conditions are on money that's coming down, the current state of the law is that's okay. And that's the source of a lot of the bloat at the federal level. They're basically just a giant tax redistribution outfit where they take a bunch of money up, they attach strings, and they send it back out to the states. So if, and I've heard a little bit about this, but it's been recent, and I'm not up to speed on the legality of this stuff yet. But if it's something that is clearly offered to the states, then it becomes a policy decision whether the states take that money or not. Even if it would otherwise be illegal for the federal government to mandate it, if they make it voluntary as a condition of receiving money, then it's up to the state governments to decide whether they want to do that or not.
Okay, so my second backup question on that, again, the states can take the funds, and I hear this all the way at the county commission level. Once the funds come down, it's always, basically, it's not mandatory that we have to pay anything back. So if the money's coming down and it comes down through the agencies to our agency, where do the people have a say on that? And how do we fight that back? Because ultimately, we have laws on the books that say we're not supposed to do it, but you have an agency that's pushing it through, and they automatically can do it. if they take the funds?
I mean, I think it depends on exactly what the laws on the books say, and I don't want to get too far out over my skis because I haven't looked at the exact language. But the way to fight back is getting your state government to think differently about it. I mean, at the executive and legislative levels. If the conditions are clear on the money, and if there's not a clear prohibition in the law, then it's a purely policy decision. If there is a prohibition in the law, then it becomes very contextual as to exactly what the prohibition is, exactly what the conditions are. So I realize that's not the best answer, but I think that the first thing to do is elevate it, get attention on it, so that people are looking at what exactly the controlling language is, and making sure that everyone's aware of it. And in Tennessee, the General Assembly, it's set up differently than the federal government. The General Assembly has a lot more authority. The executive branch does not have as much authority as the balance in the federal side. Sometimes people don't notice that, but going to your representative and raising these issues and having them raise these issues can be very effective because of the way the Tennessee government's structured. I mean, the GovOps committee in our legislature is very different than anything you see at the federal level. So there are definitely avenues to pursue regardless of like the underlying facts if you don't like what the policy is.
Okay, thank you.
General Skrmetti, thank you so much for coming. I was involved with a group of 13 counties, a grassroots group, who were following legislation this year. And with your preface that you said about the rule of law being so important, it came up, we saw some interesting legislation come up about sovereignty and nullification. And we got really excited about it because we're grassroots and we represent 13 counties and about 12,000 folks. And when it started going to the committee level, you gave an interview and it killed all the talk about it. So could you just talk a little bit about what your mindset is about nullification and sovereignty issues for the state? Because if the rule of law is not being followed and the next administration is not the one that we want from a grassroots level, I think this process of rule of law being destroyed is going to continue. So we need to start talking about sovereignty and nullification issues. Can you talk about that a little bit?
Yeah, I'm happy to. And I recognize there are a lot of people who are concerned about federal overreach like I am, who are very attached to nullification as a strategy. And I think we're, of like mind that the federal government is overreaching severely. My take on this, and this is Andrew Jackson's take, I mean, this has been around for hundreds of years, it's been a conversation for hundreds of years, is nullification is something that happens outside our constitutional system. So we've got this system that has checks and balances. If there's overreach in the system should be able to correct itself, and that means going to court and getting the courts to say the federal government's overreaching. Nullification, where you just say, we're not going to let this law apply here, is not something that's recognized as part of that structure. And once somebody starts doing it, then everybody's going to start doing it. And California and New York are going to ignore every restriction that they don't want in the other direction. And I mean, the whole thing's just going to fall apart. We're not going to have a constitutional order anymore. Now, there is a natural right recognized very early in the Tennessee Constitution. I think it's the first or second sentence to restructure government, the right to revolution when that's necessary. In 1776, the founders looked at the situation they were in and said, this is intolerable, we're setting up a new government. That's the ultimate recourse. I don't say that we should take that at all lightly. I think that is a huge deal. I would not encourage it unless and until things are truly, completely intolerable. But at the end of the day, that is the ultimate recourse. And nullification is a step very firmly in that direction. You're stepping away from the constitutional order and saying the legitimacy of this government is no longer valid. That is a step that you can't really take back. Once you start saying that this is not a legitimate system, you can't turn around and say, but we need the system to work the right way. Nullification is the first step on the road to revolution. And again, like, that is the ultimate recourse. I've taken an oath to the Constitution of the United States and the oath of the Constitution of Tennessee. I'm wed to those orders, and I think, there's still ample opportunity for the system to correct itself. We've had a lot of victories in court. I also think there's a lot of, maybe not misinformation, that's such a bad word these days anyway, but misunderstanding, because I know Ron DeSantis, who's a law school friend of mine, I think the world of him. He is a really good guy. He used to help pick up chairs after the meetings to give you an indication of the quality human being that he is. He said, we're not going to allow this Title IX nonsense in Florida, but then he immediately turned to his AG and said, you need to sue so that we don't need to apply this Title IX nonsense in Florida. He wasn't calling out the National Guard to stop the Department of Education from coming in. So I'm sympathetic with the idea that nullification is a response, but it starts unraveling all the threads that hold the union together. And if we ever do that, I mean, it's truly a slippery slope. So I appreciate there's a long tradition of that. I know that people have been thinking a lot about it, writing a lot about it, and I respect that, but I just can't view nullification. As the Attorney General, I'm a law guy. I have to be a law guy. Nullification is something that happens outside the sphere of the law.
Thank you so much.
Thank you for the question.
Good afternoon.
Good afternoon.
I'm Marla Luciano, and first of all, I just want to thank you so much for coming out. Of all your comments, I think my favorite was your comment about an ivory tower and not wanting to be one. I think we all can feel your care and concern. Having said that, I'm curious, does your, don't worry, it's not a trick question.
Okay. It's always dangerous.
You literally held your breath. Having said that, I'm curious if your office helps the general public with questions outside of forums such as this, and if you do, what's the best way to get in touch with you?
So we don't. We are legally limited to representing our clients, so we can't provide legal advice to the general public. I try to get out and speak, but if you have a legal question, we are the wrong people to go to with that. There are local resources. Your legislators can often get answers to legal questions for you. But although we care a lot about the people of Tennessee and we work on your behalf, as a formal legal matter, our clients are the state officials and the state itself, and so we can't provide any legal advice to the public.
Okay, and if there's a complaint, is there a way to get in touch with your office?
Yeah, absolutely.
In the best
Khaki
way.
Kerrigan is my deputy chief of staff. She's right back there, and she deals a lot with external relations and with people complaining. So please get her card and do not hesitate
Oh,
to
totally
tell her
threw you under
what
the
you
bus.
need. And
Totally threw her
she'll
under the
run
bus.
it internally.
All right, thank you. I know.
And if it's a consumer complaint, if you're concerned about something that a company has done, tn.gov/consumer is the way to file a formal complaint there. And that's a great process. We got people whose only job is to do that intake, route it to the right place, try to get it fixed.
And so to send her an email would be the best course of action for the general public?
Yes.
Perfect. Thank you so much. I really appreciate it.
Thank you.
Hi, my name's Joe McCall. Thank you for being here today. My question involves the Tennessee law intent to go armed, which, of course, as it sounds, prohibits going armed, but provides an affirmative defense in case you happen to be either stopped or arrested. You can tell it to the judge, which to me, on its face, is a ridiculous law, and in light of Bruin, how can it possibly be constitutional?
So there's an attorney general request about this issue pending. So I cannot comment on the substance of it. However, Bruin is obviously a very significant case. And, it's clear that the Supreme Court is clarifying Second Amendment law significantly these days when it was not. It was left largely underdefined by the courts in the past. So I understand what's motivating the question, but because there's the opinion request out, I can't offer any opinion outside that process at this time.
Okay, well, thank you.
Thank you. Sorry about that.
My name's David Taylor, and thank you, Attorney General, for being here. We really appreciate it. I have an election integrity question, which is something I think is really important. And I would say at the outset, I don't think is or should be a partisan issue at all. Everybody should want, free and fair and, proper elections. There have been allegations that certain groups in the country are taking large, potentially illegal donations under federal election law and laundering them. You get a case, it's turned in as though a grandmother who's living on minor Social Security has donated the max, and if you go ask Grandma, she doesn't know anything about this. There are allegations, I know Virginia and Wyoming are both, it's the AG in Virginia and the Secretary of State in Wyoming are investigating Act Blue for that. There could equally be, organizations like that on the other side doing it. Is your office considering investigating that sort of thing happening in Tennessee? And if you're not, would you?
So Jason Miyares, the Attorney General of Virginia, is a really good friend of mine. We do a lot of work together, and I was talking to him last week about this issue. He has broad investigative authority to look at criminal fraud and to look at election violations that I don't have. So I have seen the complaints about Act Blue, and some of them look very concerning, that there is something going on there that is not transparent. We don't have any specific complaints about anyone being defrauded in Tennessee, which would invoke my Consumer Protection Authority. And so, I am interested in knowing whether there is a way to look at it and determine what, if any, misconduct happened in Tennessee. There's not an apparent hook for my authority into that yet. The DAs have the fraud authority here, not me. But it's very concerning. I mean, if there are donations that are being laundered in ways that evade transparency, evade election laws, that's bad, and that undermines people's faith in the system. It undermines the fairness of elections, and it's illegal. So it's very concerning, and I wish I could give a more straightforward answer, but the hooks that are being used in other states, I just don't have them.
Thank you. And Lowell, that might be something for the legislature to take up.
I'm Susan Gingrich, and I do follow you on X, Twitter. My question has to do with the Hatch Act. I'm a very firm believer in the Hatch Act for civil servants. I come from a state where people were disciplined or prosecuted, and I don't like what's happening in D.C., and I'd like to know what is Tennessee's policy, and are people disciplined or fired for violating the Hatch Act?
So the Hatch Act applies in Tennessee. We have our own Hatch Act. I'm not aware offhand of anyone being disciplined, but I'm not aware of offhand of any violations of it. I mean, I know it's something that we're concerned with and take pains to avoid. And I know that there are other parts of the state government that are very cognizant of the Hatch Act and want to avoid violating it. If anybody does violate it, I would imagine that there should be some consequences. I know there's a whole range of violations. I mean, often there are inadvertent little things, sometimes there are big things. When I was at the Department of Justice, what really burned me up was the arbitrary enforcement. So some people would have blatantly political things up, and they would hear nothing about it. Other people would have what was a relatively ticky-tack violation, and they would get a stern talking to. So I think whatever the enforcement is, it has to be uniform and across the board. And I don't know if this means that I'm oblivious or if it means that we're doing well here, but it's just not an issue that's been on my radar a lot recently.
Okay, would it be reported to your office, though?
I think it would go to the comptroller's office.
Okay.
I'm not 100% sure about that, but I think that's who handles Hatch Act violation complaints.
Thank you.
Thank you.
Attorney General, thank you for being here with us. I'm wearing my Weaver.
Yeah, we match.
Yes. This is a local question. It has to do with, first of all, I try to get involved in a lot of local politics issues, and, be it at the school board, county commissioner meetings. I'm very upset with the way the local governments here have forced a tax upon us. We have county commissioners that are rude, calling us out in Tellico Village as people with the pitchforks and torches and carpetbaggers, and, I take offense to that, but I also serve on a local election integrity group. So we're trying to get out there and motivate people to vote, and but the real problem I'm having is with these local groups. Now, because of the tax that they just forced on us, a lot of us have actually contacted the state comptroller's office, asking for an investigation, fraud, waste, and abuse, whatever. Haven't heard anything, nothing. I don't know how to get to the answer as to what they're doing. I don't know if they're just hoping it just passes and nobody, makes an issue out of it. But we have a large group that's making an issue out of it. We've got over 1,000 people right now in writing saying, we object to what's going on. And, and we're pushing more, and if we have to just use that as an avenue to vote out the commissioners and the school board members, then that's what we're going to do. But, there's a lot of...
Do you have a question, please?
Yeah, I'm asking what can be done to get the comptroller's office to respond to our questions.
I mean, sometimes they may be investigating and not want to talk about investigations in progress. I really don't know. I mean, they've got some pretty developed procedures over there. Working through a legislator can sometimes get answers if you otherwise can't, but my understanding is usually they're pretty responsive over there. So I can't speak to why they might not be in a given case.
Yeah, I've tried through a legislature, but I can't get anywhere with that, so.
Yeah, I mean, in Tennessee, each office is independent, so, the comptroller is like my office or like the Secretary of State
Yeah.
or like the treasurer, and so.
It is frustrating when you're trying to do something and get answers and, nobody's responding, so. All right. Thank you.
Thank you, sorry.
Last question.
Good evening, and thank you for your opening comments. As an individual who has already escaped 2 states, your opening remarks were very reassuring that we made the right decision.
Good.
In my view, over the last at least 40 years, the schools everywhere have absorbed, controlled, and poorly serviced our children and in turn their parents. To your earlier point, if we elect the right people to our school boards, they should better reflect what many people believe. But we also know that more often than not, school board candidates are chosen and funded by the unions. Is there somewhere in state statute or the state constitution where your office can challenge this disconnect between the promise to educate and the performance? I mean, for example, we have TCAT in here. And recently, our school superintendent told a group of us to not trust the TCAT scores, that they do not truly reflect the performance of the children in his schools. I tend to really disagree with that. So is there somewhere in the promise the state makes to parents and to children where they are not performing as required that your office can participate?
I'm not aware of anything offhand. The courts have looked at that constitutional provision mostly in terms of funding. And they try not to get too involved in it, I think because they don't want to overstep and have judges micromanaging the schools. So I'm not aware of anything that would create a good legal avenue to resolve those issues. You know, obviously, there's the school choice legislation that's been proposed that potentially changes that up to some extent at least. But, I mean, I think that's one that really comes down to democracy. And, you know, it's taken a long time to get us to the point where the education system is today, and that probably means that we can't solve the problems with it quickly. I mean, it's going to be a generational effort, would be my guess. You know, my mom was a school teacher. We're homeschooling our kids right now. I went to public schools. I'm very grateful for my public school education, but I'm also very grateful that we have the opportunity for my wife to be home with them, giving them a lot of attention. And, you know, at the end of the day, education is incredibly important, not just for the kids, not just for their financial opportunities, but for the country. Because we're a self-governing people, and if we have people who are dumb, we can't stay a self-governing people. I mean, like, you cannot have an ignorant electorate and not fall back into some form of dictatorship or other tyranny. So it is super important we get the education stuff right. But I do think that's an area where the self-governing people need to be self-governing. I don't think there's a workaround, because if you start trying to read the education provision really, really broadly, then you're just giving judges all the power over local education. And I hope our courts would be reluctant to do that. And I think for whatever immediate problem you're solving, you're probably creating a lot more problems in the long run. So I appreciate the question. I don't want to rain on your parade or anything, but I don't think there's probably a legal solution there.
All right, well, thank you.
Thank you. Again, thank you so much for the hospitality. Thank you for the questions. Thank you for the grace when I can't answer it or can't answer it well. You know, and I do apologize about that Bruin question, because there's a lot that could be said there. But I really do appreciate how much attention everyone's paying to what's going on in the state, to what my office has been doing. The questions indicate people who really care a lot about government. And whether you agree with it or disagree with it, you got to care about it. Because if you don't, who else is going to? And we're all responsible for this ourselves. And so the fact that you're stepping up and taking responsibility as citizens, it's important for now and for the generations to come. So thank you. And thanks for listening to me. Thanks for bearing with me through the antitrust part. And thanks for the encouragement.